go. 105. Welcome, Central Iceland. You know, there are two locations out there. You all have your homework assignments. You know, you don't do elaborate introductions here. You have Professor Landsman's CV, very impressive CV, and that's the extent of my introduction. We're delighted to have him here from DePaul Law School by way of Brooklyn Law School, where he is now a visiting professor. And without further ado, Professor Landsman, thank you for being here. We look forward to your remarks.
Well, I wanted to begin by thanking Judge Deary for inviting me to speak. It was a brave decision on his part because he's never seen me do anything like this. So if it's bad, it's my fault, and you know, if you like it, because he made a wonderful pick. I'm the Robert A. Clifford Professor of Tort Law and Social Policy at DePaul University in Chicago, and also, as the judge said, a visiting professor, actually the last 3 or 4 years at Brooklyn Law School. Two things about time. The first one is that the time is so short that what you're getting is sort of the cliff notes of the issues about these particular cases. So that if you really are interested, there's a book out there, and I happen to have written it, Crimes of the Holocaust, still available on Amazon, and if not, from my mom, who has about 2 dozen copies. The other thing about time, the time is fairly short, and so if there are questions as I go along, feel free to ask them. That you know, I've got a lot of stuff in here, but because we have a limited time, if you have something that you really think needs to be clarified or responded to, please feel free to do that. Of course, I assume everybody understands that these views are my own, that they're not endorsed by anyone else necessarily. They're the views of a Jewish American academic, former litigator who thought that one of the things that might be useful for him to work on was thinking about how we make the process by which we pursue people who have committed the worst atrocities work better as a matter of law. And so that's really where all of this came from. Some of it might strike you as controversial. I am not without criticism of the Nuremberg trial and the Eichmann trial, as you'll see. And when Hannah Arendt wrote a series of articles that were turned into a book on this matter, she ignited a controversy that lasted throughout her entire career. So if some of this strikes you that way, I think that may be a healthy reaction, and I'll try and respond to your questions. There are more seats up here, so come on in and don't be shy. Our story does begin at Nuremberg. Nuremberg is what happens at the end of the Second World War as an answer to the question, what should we do with the high-ranking criminals captured alive at the end of the Second World War? There was no clear legal precedent. At the end of the First World War, the German Kaiser, the titular head of the German government, fled to Holland, where he was granted asylum, so he was never prosecuted. There were a series of trials held at Leipzig by German judges. They were, by everyone's agreement, a fiasco, and gave the idea of prosecuting for war crimes a bad name in that time, 1919, 1920. Perhaps the most horrifying events were those involving the Turks and their Armenian population. Perhaps as many as 1 million Armenians were massacred during the First World War by the Turkish government. The British began prosecutions which they never completed for a variety of political and, I guess, social reasons. Hostages were being held. British hostages were being held. Hitler is said in 1939 to have commented on this, and this quote always reminds me what the stakes are when we talk about atrocity and the world's dealing with atrocity. He's said to have been addressing his field generals as they were about to begin the war in Poland, and he was urging them to be as severe as they could be in dealing with hostile populations. And he said, "Who, after all, speaks today of the annihilation of the Armenians. That's a very chilling remark 20 years after those events. So we come to Nuremberg. We come to discussions amongst the Allies about what to do. The Brits wanted to shoot all the high-ranking people seized from the Nazi government, and that was all they wanted. If they had had their way, there would have been no trials. Both the Americans and the Soviets, however, disagreed. The Soviets had very substantial experience some 10 years before with what we now consider to have been show trials, mockeries of justice, performances prepared through extensive interrogation, terror tactics with respect to the defendants. The United States also wanted trials, and so it was sort of a 2-to-1 vote. But the United States idea was trials that really conformed more or less to our notions of what fair criminal proceedings are. The hero in this early tale is Secretary of War Stimson, who insisted that as far as he was concerned, the Germans who had been captured had to be given something like due process. And he maneuvered to persuade his boss, the President of the United States, that that was a good idea, and eventually succeeded. He succeeded perhaps for some deeper reasons. One was an American reason, and that was a felt need for a record of what the Nazis had done in their time in power from 1933 to 1945. This notion of the need for a record was driven by Roosevelt's own experience in trying to get America to commit to the Second World War, despite strong resistance, isolationism in America, and revisionism about what the history of the First World War had been. In addition, I think the United States and all of the world had just come through the most horrific war ever experienced on the planet. The devastation of the war suggested that things as they had been done could not continue to be done the same way. And there was a profound turning, I think, towards the notion of the rule of law, towards a different way, a better way of doing things. So there was an agreement to create the International Military Tribunal, IMT, at Nuremberg in Germany. Much of it was negotiated in terms of what its structure and processes would be. Much of it was improvised as the trials went along. There was no law to begin with to prosecute under. The victorious Allies created and recognized crimes against peace, notions of war crimes, although it has a very long history, crimes against humanity, and an American edition, conspiracy. There was no fixed procedure. This had never been done before. There simply wasn't a template. There wasn't a set of guidelines. But an adversarial system was adopted in which the parties would contend against each other and would offer the proof. Now, this is a troubling notion because the individuals representing the Nazi defendants were themselves mostly former members of the Nazi Party who had never tried adversarial proceedings in their lives. There's an imbalance introduced at the very beginning of the Nuremberg process. There were no rules of evidence. This is particularly horrifying to me. I teach evidence, so that I'd be sort of out of a job if we followed this approach to trying cases. And with respect to the judges, it was a very interesting question. Neutrality, fairness, or victors' representatives? No answer was readily apparent. The Soviets nominated as their judge, and he sat, the person who had been their chief prosecutor. The other countries nominated and selected according to whatever decisions they thought were appropriate, but certainly neutrality and judicial acumen were not particularly the focus of the selection process, as far as I can tell. In addition, for Nuremberg, there were no simple available sources of proof. If you were going to try these Nazis, you were going to have to dig through literally tons, or if you put them in shelf space, miles of documents to see what had happened and what might be criminally prosecutable. The theater in which you would focus would be all of Europe, the entirety of the continent. The amount of time you would be considering would perhaps span from 1933 to 1945, 12 years, an enormous challenge for any prosecution team to assemble proof of the sort that might be needed. In fact, it was not only a challenge with respect to proof, it was a challenge to say, well, who are we to prosecute? There might be 3 or 4 outstanding leaders of the Nazi government whom one might focus upon, the Görings and Ribbentrops of the world. But mostly, it was far less well-known individuals. How to select who ought to be prosecuted? Who had committed the worst crimes? How are we to know who to focus upon? Or might we focus upon representatives of the various arms of the Nazi government? If we did that, however, it would be group prosecution more than individual prosecution. Tension probably never quite resolved at Nuremberg. Nuremberg was, I think, a recipe for failure. There was no fixed law. There was an adversary system where one side had the most skilled lawyers imaginable, the other side had people who had never tried a case in their lives. The judges were not bound to be neutral. The evidence included everything imaginable that might be uncovered anywhere in the continent, touching on any of 12 years of history. It might include the most horrific proof you can imagine. And I've got to say, as I was reading through these materials, some of the darkest times I've ever spent in my life were just reading the transcripts of some of the evidence that was introduced at Nuremberg. It's heart-rending material. It's soul-deadening material. And to think of it being proven for the first time in a court of law to people who had not heard of the Holocaust, who didn't understand what the Einsatzgruppen had done, it must have had extraordinary prejudicial impact. The cost of mounting this trial was also exorbitant. But despite all of that, Nuremberg is not a failure, but rather a brilliant success. Why? Why was Nuremberg a brilliant success? Well, first of all, America put up the money. It built the courthouse. It paid thousands of lawyers and others to search through the Nazis' massive archives. And that's the second point. There were massive archives. The Nazis loved to keep records. They kept records of everything you can imagine and things you can't even imagine. And all you had to do was have the money and time to look. And America put up the money, and a remarkable effort at discovery mined those materials quite amazingly. In addition, one's got to say the defendants who were put on trial were grossly and clearly guilty. You weren't going to make a miscarriage of justice sort of mistake with respect to most of them. Their identities were also indisputable. It wasn't as if you had gotten the wrong guy. These were people who were well known. They were the heads of various entities. What they had done was fairly well recorded. You didn't have the mistaken application of the law kind of risk, at least not in a great sense. But probably the miracle of Nuremberg, and why it's wonderful to talk about it here in the courthouse of the Eastern District of New York, is that there were judges who were the soul of fairness, who did not accept a position as the representative of their nations, who demanded instead that the process be fair. And they were led by an elderly British law lord whose name was Geoffrey Lawrence, who when selected did not seem like a very promising candidate. He was 66 years of age. He had just a middling sort of career. He was not highly thought of in the British bar, and he came to Nuremberg a more or less unknown quantity. And this man led this trial to shining example of fairness after shining example of fairness from the beginning on. When the United States lawyers wanted to produce hundreds of documents in a 3-hour period, he said, no, the defendants can't read them, the court can't read them, we're going to have a trial here. We're not going to have a blizzard of paper. Extraordinary decision on this man's part. when the German lawyers, many of whom had Nazi pasts, were placed under a variety of pressures, he insisted that they be protected, that they be respected, that they be given an opportunity to do the best job that they could. Again and again and again, this man, the Chief Judge, Jeffrey Lawrence, made all the difference in the world. Could one person make a difference? Boy, can he. There were other good judges here. The second British judge, Judge Burkett, the two American judges, Judge Biddle and Judge Parker, all really worked to produce fair results. And it was their work together that I think really was the key to success. There were also wonderful prosecutors. The chief prosecutor was Robert Jackson, a member of the Supreme Court of the United States at that time. And in the end, what the world saw was what these judges produced: a fair trial decided on the evidence. And 3 of the 22 accused were acquitted. An extraordinary message when you think about what the Brits had wanted to do, which was to shoot everybody, and what the Soviets had wanted to do, which is to have a show trial which would convict everybody, and then you shoot them. This is an extraordinary achievement, not one that one would have predicted when you started out. What does the world make of all of this? That Nuremberg was not just victor's justice, that the rule of law might actually have hope for making the world a better and safer and more decent place. What doesn't the world see when Nuremberg is concluded? The cost, the evidence problems, the incredible power of atrocity evidence to overwhelm the decision maker, and the need for exemplary, superlative judges. These are not clear from the record of, Nuremberg. So things sat more or less. There were a number of trials, successor trials at Nuremberg and other trials with respect to war crimes and so forth, but nothing that addressed the grand scale of atrocity. And the world seems not to have been particularly focused on what Nuremberg meant, perhaps until as late as 1960. Then a new trial was begun, which reignited our interest in these matters in the most intense way. It began when a man named Adolf Eichmann, the chief administrator responsible for transporting Europe's Jews to the killing centers in Eastern Europe, was found to be hiding under an assumed name in Argentina. Having heard this, the Jewish state dispatched agents of its intelligence service to kidnap Eichmann from Argentina. The world's response was astoundingly harsh. It was viewed, quite rightly, as an affront to international law to have taken Eichmann by kidnapping. It was seen as the acts of an upstart nation, a little bit more than a decade old at that time, one that didn't seem to be playing with all the other members of the world's community. The press in the United States described what the Israelis had done as the law of the jungle, inviting the most harsh sort of analysis of this disobedience to notions of law and international comedy. Israel, confronting the problem of what to do with this man, Adolf Eichmann, of course, turned to the Nuremberg precedent. As I've said, I think a glowing precedent, one that might be attractive in terms of seeking the kind of justice that Israel might have hoped for. Again, the questions are, however, what law are we going to use? Israel had a law, the Nazi and Nazi Collaborators Punishment Act of 1950, but it was little more than a restatement of the principles that had been designed at Nuremberg. And mostly this law had been designed not for people like Eichmann, but rather for collaborators who lived in Israel. So it was a difficult sort of situation for describing how you would proceed. Well, it would certainly be an adversary system again. That was the one that the Israelis had adopted from the British, and one we would all recognize as very similar to the American system. And again, we would have lawyer versus lawyer in making the proof. And on the one side would be the whole of the Israeli government and a special branch of the Israeli National Police. On the other side, one lawyer, a man named Robert Servatius, with one assistant, Dieter Wittenbrook. And they were it against the state of Israel. Again, that imbalance that an adversary system where the adversaries are not evenly matched in terms of resources and background and so forth raises questions. Again, there would be no evidentiary restrictions, that whatever evidence the prosecution thought was worthwhile would be allowed to be introduced, that in part because of an interpretation of the court with respect to how the indictment was drafted. The judges, well, the law specified that they ought to be picked by the chief judge of the District Court of Jerusalem. But the chief judge of the District Court of Jerusalem was a man named Benjamin Halevi. Benjamin Halevi had presided at a trial of a man named Rudolf Kastner. Eichmann's name had come up in that trial, and the judge had said that Eichmann was a devil, and why didn't someone assassinate him? This is one of the judges who was to run the Eichmann trial. That trial itself was deeply troubling to Israel. Kastner was assassinated on the streets of Tel Aviv shortly after the trial had concluded. It was a challenge to the political and legal infrastructure, what to do about Judge Halevi, what to do about who would sit in judgment of Eichmann. And eventually, the Knesset, the Israeli parliament, changed the law. And it said that the youngest member of the, that the chief judge of the Supreme Court could appoint the chief judge for the trial. And the judge turned to the youngest member of the Supreme Court, a man named Moshe Landau. And then Judge Halevi was allowed to sit along with someone else he would designate. The trial in Jerusalem of Adolf Eichmann was very different from the trial at Nuremberg. At Nuremberg, the essence of the case was documents. It was all about what the Nazis had written in their files and what the American and other investigators had found. In Jerusalem, the center of gravity of the case was not documents, although there were many, but rather the testimony of 121 witnesses. Now, all of Nuremberg, all the Nazi crimes tried together, 33 live witnesses were called by the prosecutors. In Jerusalem, 4 times as many live witnesses. Testimony, rather than documents, were key. In addition, the focus really shifts from the operations of government to the experience of victims, because most of those 121 witnesses were victims who had suffered at the hands of the Nazis. The trial of this one middle-ranking Nazi official took more time than the 22 or 21 at Nuremberg. The center of the case had become horrifying, hair-raising, awful to read or look at testimony about what had been done to murder the Jews of Europe. Was the Eichmann trial a recipe for success? Again, as I had said with Nuremberg, I think hardly is it a chance to think that the system's going to shine. You start by kidnapping the defendant from a foreign nation in violation of international law. You bring him to a country where almost every citizen is viscerally and pervasively affected by the crimes with which that defendant is accused. The evidence that you're going to produce day in and day out is all the most powerfully prejudicial you can imagine, atrocity evidence of the most difficult and challenging sort. One of the 3 judges on the panel, Benjamin Halevi, is on record as having said that the defendant is a devil who ought to have been assassinated. Defense counsel stands alone against the government of Israel. Nazi witnesses are barred from entering the country because the Israeli government says it will prosecute any who shows his face within the territorial limits of Israel. Yet despite it all, like Nuremberg, I believe that the Eichmann trial is a brilliant success. Why? Once again, it's the story of an outstanding judge. Moshe Landau, like his predecessor, Jeffrey Lawrence, is the soul of fairness in this trial. He works in every line of the transcript, as far as I could see, to make sure the case was tried properly, fairly, and with attention to the demands of the law. Now, I was lecturing some years ago at Hebrew University and was taken aside after I did a talk not wildly different from this and said, you know, I think you're right about I think you're right about Judge Landau, at least in that trial. But later on, he was seen in Israel as a pretty tough guy who was not always the fairest judge imaginable. But in this case, he was miraculous, I think. Even the harshest critic of the trial, Hannah Arendt, in her brilliant but flawed book, Eichmann in Jerusalem, which I recommend to you, says of Landau that he truly was extraordinary in this trial, and I believe that's true. He did not allow the court to be overcome by the atrocity evidence. Easy to give into. He did not allow the prosecutor to run roughshod, despite the disparity of resources and of knowledge. One knows the Israeli system, the other simply does not. And he led the court to acquit Eichmann of charges which truly were not based on sufficient evidence. Eichmann did not have anything to do with what went on in the killing camps themselves. He just delivered the victims there, knowing full well what he was doing, but had no control in the camps. He had no control over the killers in the Nazi Wehrmacht, the so-called Einsatzgruppen, which followed behind the German army and was responsible for killing communists and Jews wherever they might be found. And one at a time, by bullets, killed perhaps 1.5 million people. Those were not his crimes, and Landau said so. Also, of course, Eichmann was a monster. We knew this man. There was no question about his identity. We knew his crimes, and to have convicted him was an entirely defensible legal proceeding. Finally, and this may be the greatest achievement of the Eichmann case, it awakened the world to the details of the Holocaust. It was from that time on that the debate that you still see every day, perhaps in the newspapers, but certainly every week in the newspapers and in common discourse in the media and so forth, began at that trial in 1961. It began as much, I think, because of Hannah Arendt's controversial book as anything else, but we have not since then ever forgotten the challenge of the Holocaust and the issues that the Holocaust raised and that recent history has reminded us of. The risks, I think, in the Eichmann case were enormous for the nation state of Israel, for just proceedings with respect to atrocity, and yet the success was great. And we lawyers recognize the continuation of a line of precedent from Nuremberg to Eichmann. So things more or less sat until the late 1970s, when the world finally began to internalize the message of the proof, particularly of the Eichmann case, to realize that the Holocaust was not the product simply of Nazi chieftains, but was also the product of bestial foot soldiers, and that all of those foot soldiers had not been called to account for what they had done in the camps, for what they had done on the battlefield, for what they had done throughout all of Europe. So a search for those criminals began. The United States was one of the places in which that search was most particularly begun, and a government entity was created to carry on the search. It was the Special Litigation Unit of the Immigration Service. Its name was eventually changed to the Office of Special Investigations, or OSI. As with so much in America, the search for Nazi henchmen became a political issue. Became a political issue in the presidential election between Gerald Ford and Jimmy Carter. The political focus created a pressure on government lawyers searching for Nazis to achieve results. John Demjanjuk, an auto worker in Cleveland who had immigrated to the United States after the Second World War, was a name that the OSI eventually came to focus upon. The evidence strongly suggested that Demjanjuk was a camp guard who had, after the war, been admitted to the United States and had become a naturalized citizen. The evidence was quite suggestive. He listed on his immigration papers residence at a place that was only a concentration camp. He had obliterated a tattoo under his arm which indicated his status as an adjunct to the SS. He looked like a brute. He had a balding pate, not unlike mine, and he had just a brutal look to him. And he was a liar from the first word out of his mouth to the last. He never admitted he was involved with the Nazi army. He never admitted that he had ever been at a camp. He never admitted anything whatsoever. The American investigators were feverishly searching for evidence of the sort that would allow for denaturalization and perhaps punishment in another nation of some of the people like Demjanjuk. And what eventually they found was, they thought, identification of John Demjanjuk as a particularly notorious prison guard at a death camp called Treblinka. The name of the guard was Ivan Grozny, or Ivan the Terrible. He was the operator of the gas machinery which killed Jews in gas chambers at Treblinka. He was particularly vile in that he had by his side a sword, and as the victims came by, he would sometimes lash out and cut off an ear. This was the kind of man that the American officials thought they had found. The U.S. set out to denaturalize and to deport Mr. Demjanjuk. Unfortunately, in this case, however, compared with Nuremberg, compared with the proceedings against Eichmann, there was just one document. A document from a transit camp called Trebniki, where John Demjanjuk had worked for some period of time. This document suggested that he had moved on to another camp called Sobibor. It did not list a place called Treblinka. It didn't mention that place where he was accused of being Ivan Grozny, Ivan the Terrible. The United States found 5 eyewitnesses who would say John Demjanjuk was Ivan Grozny and had been at the Treblinka camp. The government team that put together this case faced a great deal of ambiguity in the evidence. There was a lot of stuff that suggested Demjanjuk was not that Ivan the Terrible. He was just Ivan the Bad from somewhere else, had done something else. And, so there was a lot of back and forth within the prosecutorial ranks about what to do with this particular case. Eventually, it was decided to put the doubts to one side and to press forward. Unfortunately, there may also have been a decision to put some of the evidence to one side. The Sixth Circuit eventually thought so, found that the prosecutors had committed a fraud on the court when they had not revealed some of the evidence that they had uncovered that did not serve the Demjanjuk is Ivan the Terrible theory. Judge Battisti, the federal judge sitting to decide this case in Cleveland, was convinced by the prosecutor's proof and denaturalized Demjanjuk. In the meantime, Israel and the United States were in contact with each other and agreed to extradite Demjanjuk from the United States to Israel to stand trial as Ivan Grozny of Treblinka. That was what was understood in the extradition process. That was the crime that would be pursued. Israel then began to prepare its case. The risks to justice were once again huge. The publicity, the media attention to this case in Israel was enormous, created overwhelming pressure to convict this particular defendant. The evidence, if imaginable, was more harrowing than it had been previously. Why? Because everything is about Treblinka. Everything is about this death camp, about the murder of the people who were shipped there. Again, the law is amorphous. There's no check now, however, by documentary proof. All we have is the word of a serious, the limited number of eyewitnesses. The defendant is no longer a person of high rank, nor is he notorious in any way, nor do we know for sure that he is the person we say that he is. In addition, Mr. Demjanjuk had the misfortune of having incredibly unskilled American representation. His lead counsel was an absolute disaster. If you need any examples, lead counsel recruited and examined 2 expert handwriting witnesses. After they testified in Israel, one attempted to commit suicide. She said she was so embarrassed by what had happened to her in court. The other said, "My career is over." This is not quality lawyering, I think, and we would probably all agree that you don't want to put those kinds of witnesses on the stand. That's how bad Demjanjuk's American lawyer was. In addition, this trial takes place 45 years or more after the events to be recounted. Whatever one thinks of witness memory, 45 years is a hugely long time. The hope, of course, again, would be that we would have a great judge or great judges who would make the thing work right, more or less. Unfortunately, luck ran out with respect to that matter. The presiding judge, again, the youngest member of the Israeli Supreme Court, was a man named Dov Levin. And he begins the written opinion of the district court convicting Demjanjuk of being Ivan the Terrible by saying, "We are going to erect a monument to those who were killed at Treblinka." When the decision maker decides to create monuments rather than decide the facts of a criminal case, I think we're usually in trouble. That the inconsistencies in the witness testimony were said not to have been errors or failures of memory or anything of the sort. The witnesses were said to have memories that were holy, that could not be challenged. And that when they were wrong, it was because of wishful thinking. That's the court's phrase. These are deeply troubling notions, and they lead to conviction on all of the charges. Within a year, the case begins to unravel. 60 Minutes runs a interview with a woman who was a prostitute at a village near the Treblinka camp. She admits that Ivan Grozny was a client of hers and that this man, Demjanjuk, is not Grozny. Author, whose name is Gita Sereny, who had written a number of very affecting works about the Holocaust, and especially about the camps, begins to research the question. She interviews a number of people in the Soviet Union, and they pretty consistently say that this is not the right guy. This man, Ivan Demjanjuk, was at another camp, Sobibor. He was not at Treblinka. In addition, the Soviets had sent the United States evidence in the form of 3 protocols that summarized a number of different statements from Soviet citizens indicating that there were real problems with the accusations against Demjanjuk. Those were never provided to defense and were part of the fraud on the court problem that the Sixth Circuit recognizes. Although it took a time, the Israeli Supreme Court, faced with this material, eventually decides that a miscarriage of justice had occurred, although it doesn't say in exactly those terms, and that Demjanjuk ought to be freed. In the meantime, as I said, the Sixth Circuit overturned the denaturalization decision, finding that the United States government's representatives had committed a fraud on the court. Demjanjuk came back to the United States, back to his home in Cleveland. Eventually, he would be extradited again, this time to Germany, where a trial conducted when the defendant was more than 90 years old would find that he was indeed a camp guard at Sobibor. He would die in prison. I think he died last year, 2012. What was the effect of the Demjanjuk debacle? Israel got out of the business of hunting and prosecuting Nazi criminals. It would never again look for those bestial foot soldiers or anyone else with respect to those atrocities of the Holocaust. The United States' efforts in the same regard also were substantially diminished in the wake of the Demjanjuk affair. Holocaust deniers obviously were given a kind of argument that certainly enhanced their reprehensible case. Why did it happen? Why did Demjanjuk fail so badly? Media pressure, prejudicial evidence so strong that it sweeps caution away, horrible defense counsel, the absence of fair-minded judges. These are a recipe for undermining justice not only in Israel, but in the United States as well. Now, the trajectory of mass atrocity prosecutions was not entirely deflected by Demjanjuk. Under a unique law, Canada sought to prosecute a similar sort of individual, a man named Imre Finta, of having been a captain in the Hungarian gendarmerie and to have presided over a camp where Jews were held for transit to Auschwitz and their murder. The accusations focused on perhaps the grimmest part of the Holocaust, 600,000 Hungarians of Jewish extraction slaughtered in a matter of 3 or 4 months. Finta had as his attorney a man named Douglas Christie, who consciously pursued a Holocaust denial defense. He said it didn't happen. Gas chambers are false. The whole story is a fake. And, there may have been a number of people who were killed, but this is all made up, all nonsense, all designed by the Jews to seek and secure huge reparations. Canadian law required that the case be tried to a jury, as a similar case would have been in the United States. The judge who sat in the trial was a man named Archie Campbell. Judge Campbell appears, at least to me, to have been an honorable man with liberal instincts of the sort I share, who had spent most of his career not as a trial lawyer or a prosecutor or a defense counsel, but as a policymaker. The courtroom was not his first home, and he was not highly skilled in running a jury trial. The trial itself was an absolute disaster. The prosecution follows the Nuremberg Eichmann template, big case, lots of atrocity evidence, a variety of pieces of information about those terrible events, but not very much about the defendants themselves. The key to the case, 20 elderly witnesses testifying more than 45, almost 50 years after the events that they're testifying to. They contradicted one another about where Mr. Finta was, what the defendant Finta had done. And of course, they're constantly being bombarded by defense counsel Christie's arguments about the Holocaust not having happened. Prosecution is overwhelmed by its own evidence. It doesn't have a theory. It doesn't have an explanation of who this man Finta was and why we should think he is responsible for what happened to the people put on the trains and sent to Auschwitz. Holocaust denial becomes the theme of the defense and the focus of its closing remarks. Elderly witnesses throughout the case were pummeled by the cross-examination. The trial is an absolute mess. It should come as no surprise that Imre Finta is acquitted by the Canadian jury. The case is appealed. In Canada, you can appeal an acquittal. The Supreme Court gets the case. Not only does it affirm the acquittal, but it gets the law under which prosecution was undertaken in Canada rather than an extradition to some place that would recognize the ability to prosecute. Eyeing what happened in Canada, the English government, the Australian government, and their prosecutors both throttled back prosecutions with respect to war crimes cases in each of those nations. The Nuremberg and Eichmann model had now been drawn clearly into question. At least with regard to small fry, it seems like an idea that might not be the very best. Where identity is an issue, or specific acts are not clear and easy to prove, again, is this the right way to proceed is a forceful question. After 30 or 40 or 50 years have passed, is this the right way to prosecute? It would be comforting to say that the world learned the lesson after that series of cases, but that would not be accurate as far as I'm concerned. If you look at what the International Criminal Court is doing today, it is mounting a series of lumbering, slow-moving, bloated cases involving dozens or hundreds of witnesses and producing results that take 3 or 4 or 5 years to achieve. It follows in the footsteps of the International Criminal Court for the former Yugoslavia, the so-called ICTY. The poster child of what's wrong with concluding that the Nuremberg model works for all things is the Milosevic trial, a 4-year fiasco which tended to turn the defendant into a hometown hero, at least amongst Serbs, and was terminated when the defendant died while presenting his own defense. Judge Patricia Wald of the Court of Appeals for the District of Columbia, who sat on the ICTY, excoriated that approach as slow and bloated as I've said, and that it should focus only on the most serious of defendants. Well, why study all this? Why go through this history? Why provide this kind of recitation? I think it's because the world needs to get it right. We need to make justice work with respect to atrocity. We need to understand the tools. We need to understand their limits. If we're dealing with the foot soldiers, we should not be creating Nuremberg-type cases. We should be creating processes that can address tens, hundreds, or thousands of defendants, as in Rwanda, as in the Balkans. We need to rethink the process for those minor figures. For major figures, we need to think about what was good with respect to Nuremberg and Eichmann, and what was not so good. And we need to work very hard to address that. We need to find outstanding judges that on the panels of the ICTY and ICC, we need the very best legal minds we can find. Not representatives of every country because that's the democratic way to do it, but the people who can really do the very best job. We need not to forget the Holocaust. We need to understand it as a legal challenge and to design processes that can address it. Questions, comments, anything? Judge? Thank you. Well, some of them were the successor trials at Nuremberg, run by the Americans.
They were smaller trials.
Right. What was interesting in those successor trials was a real focus on what each individual defendant had done. And it was really a shift away from these broader notion of crimes against humanity to more specific kinds of criminal activity. Although crimes against humanity was still, I think, a charge that was leveled. You have the doctor's trial where we really see the beginnings of medical ethics changes about experimenting on human beings and so forth and so on. We had the jurist trial, again, the misuse of the judiciary. We had the trial of the State Department sort of individuals for the, sort of prevarication and all of that, and misleading and so forth. And they had an impact, but they didn't set the template. They didn't create a kind of notion about how we ought to address atrocity and how we ought to make it work better. So my sense is that that was closer to business as usual, or something we really understood. And Nuremberg and Eichmann and these others were really trying to do something else. Right? It's a good question.
So it's the lesson then that with or without precedent, no matter how extraordinary something may be, whether we have a legal template or not, it all comes down to the quality of the people involved, particularly the quality of the judiciary, notions of simple fairness.
6 or 7 years ago, before I began this project, I never would have thought that. Having done this, I think it is about that. It is about the extraordinary impact that a notion of justice can have. And that when you begin with that kind of notion, and a background in the rule of law, that I think that those things are powerful instruments for fair proceedings. And as I said, I don't know that I ever would have thought that until I looked at these. And I just think, they're just, people count, not just principles. And these men were just extraordinary. And they gave us a gift of the rule of law and enhanced our notions of what it could do. But we always have to remember how extraordinary they were and how extraordinary you have to be to get this just right.
How do we streamline the International Criminal Court?
Well, I think that what you start to do is you start to say, no case can ever run longer than Nuremberg. It's a totally arbitrary principle, right? I mean, 9 months or 8 months or whatever, just can't do it. Sorry. You got to get all your proof in that amount of time. And then you say, all right, that may mean you only can produce X number of witnesses. It may also mean that you have to be anchored in the crimes that this particular individual committed, not in telling us the general background story. That the discipline of an adversarial lawyer, given a limited amount of time to prove a clear factual claim, is what you need. And I think that they've gotten far away from that. Sir. I think the evidence is out. Part of what we're talking about is what creates a willingness to believe in the process. What creates a buy-in? And, sometimes that means representativeness from more than one nation. But in the end, I think something more important than that is the actual quality of the proceedings. That, it is Jeffrey Lawrence, and not the fact that there's a Soviet or a French judge that sat at Nuremberg that makes the difference. So if I'm going to pick, I'm going to pick the very best judges. And, they're not so easy to find. You know, it's not as if Lawrence was thought of as the paragon of British justice, but he had that tradition, and in his heart was a kind of fairness that I guess you can't just make up. That, you know, it's there or it's not, and that's when you have the greatest chance for success. Sir.
What, if any, comparison has been done between approaches to these issues in inquisitorial models compared to adversarial models? Does it work better? What are the other problems?
It's a good question, and I don't know of any data that suggests anything clear about this. As an adversarial lawyer, my concern about inquisitorial judges is their connection to government and their responsibility to serve as prosecutors or the developers of evidence. And that the risk there seems to me to be that once you have created a case, very hard for you to step away from it and judge whether it's proven or not. You looked at all this preliminary proof and thought it was enough to try the defendant. Now, the judges who are part of the same bureaucracy as you are asked to decide whether it's true or not. There's a tension in there that I find unwholesome. Now, each system seems to me to be vulnerable. The vulnerability in the adversary system is this other one where if the lawyers are not equally good or equally well endowed with resources, you've got a real problem. And there's been some discussion in the literature about this, but I'm not clear. It's a great question, ma'am. I think that, as far as I'm concerned, these are two separate goals and separate processes. That the so-called Truth Commission is a wonderful mechanism to do exactly what you just described. Let's give people a chance to be heard and have their stories respected and to understand the history of trauma, of atrocity. That should not focus on a defendant. It should focus on the story of a nation. The success in the South African Truth and Reconciliation Commission seems to me the sort of model that I find very attractive for just that purpose. If you want to convict someone of a criminal offense, however, you shouldn't use that same case as a story of the whole of atrocity. It starts to blur the focus. It starts to distract us and can produce these miscarriages of justice as well. Ma'am? The ICC has got to get a lot better before I think there's really any particular hope. That a former student of mine is working on the Kenya prosecution on behalf of the defendants there. And the more I hear about that case, the more I think, gee, why is the ICC involved? These are tribal disputes. This is a need for a nation to heal itself, to understand the forces at work. That I just don't think that the ICC has gotten the kind of focus yet that will effectively serve as the world's ultimate arbiter of atrocity. And they may, I hope that they do, but right now I'm discouraged. Judge? Yes, I think we are. I mean, you know, it's way too simple an answer to a really subtle and difficult question. But I think we are, that in the world as it presently exists, to allow the agenda of any individual to dictate the notions of global justice is probably not good. That it's, you know, there aren't enough voices being heard. And I think unease about that is well-founded. The, you know, sort of complementarity notion, though, if the nation state can do it, let them do it. Seems to me to go some of the way to deal with those concerns, but not quite far enough. Well, thank you all for coming.